Senator Simons.
Thank you very much, Mr. Chair. I want to look at this from the other perspective. Reverse onus provisions make me extremely uncomfortable because they reverse the long-held British common law tradition of innocent until proven guilty. I mean, we're making a presumption that because somebody's been guilty of previous crimes, we're going to suspend their liberty even though we don't know if they're guilty of this new crime with which they've been charged. So I have concerns about what this means in terms of the charter statement, but I also have practical concerns about what this means downstream for remand centers all across the country, which are overflowing with people. I'm worried about what this is going to mean for cases where people are held in custody and then the Jordan decision comes into effect and their case may never get to trial because they will have run down the clock. And I worry about what this means for people who might be feeling that faced with being in remand for 18, 20 months, that they might choose to plead guilty just to expedite things and at least, if they're charged with a serious crime, get to a sometimes deemed more comfortable federal facility. I think I fit 5 questions in there. So.
Well, thank you, Senator Simons. So let me say that at the outset that it's really important to delineate the difference between what's happening in pretrial situations versus trial. So the presumption of innocence that's entrenched in Section 11 of the Charter relates to presumption of innocence that relates to your trial. Right? We're not talking about a trial. We're not talking about presuming a conviction. We're talking about the time spent, whether you're spending that in the community or whether you're spending that incarcerated prior to your trial. So that's important because the Section 11D presumption of innocence is not triggered in the same context as you were describing. The second thing I would point out to you is that, and it's fair to ask these questions, it's important at a parliamentary committee or otherwise, but the issue of a reverse onus on bail is that bail is subject to certain parameters, and I outlined some of them: confidence in the administration of justice, is there a flight risk, etc. And that has been tested in the courts, including the Supreme Court of Canada in a case called Morales. And in that case, the court found that when there's a connection to public safety, and it can be legitimated in terms of, and we have the evidence to show about the risk of reoffending, that a reverse onus in that context is constitutional and doesn't violate what is otherwise their entitlement to reasonable bail under what is called Section 11E. Section 7 of the Charter also protects liberty interests, etc. But I feel very strongly about the role that I have vis-a-vis the oath that I take, which is very different from any other minister. I have an oath to uphold the Constitution. I'm the only one that swears that. I practice constitutional law before taking this role. The Department of Justice Act requires me, vis-a-vis that charter statement you mentioned, to ascertain and make sure I'm satisfied that a bill that is being tabled is charter compliant and table that very document that you're referencing. We've taken all those steps, and I'm very much satisfied that this kind of surgical targeted approach towards serious violent offenders who use a weapon is measured and appropriate because of the evidence that demonstrates that risk of reoffending. So on the constitutionality, fair to raise those concerns. I don't share concerns about constitutional infirmity here. Far from it. I think this is in compliance with the law. In respect to the Jordan situation, I would say to you that it's an important issue, and the Jordan case is about ensuring trial within a reasonable amount of time, and issues of plea bargaining is a facet of our justice system, but certainly pleas that are entered not in good faith or honestly are something that obviously the system of justice needs to eschew and not sort of promote, and that's a concern for all of us. But if you have questions about overrepresentation, I'm also very happy to address that. Maybe that's where you're going next. So I'll let you ask the questions.
Well, I mean, I think there are other people who are going to ask those questions about overrepresentation of racialized people and Indigenous people in particular. Yeah. But I'm really more concerned with the practical circumstances. I mean, there's only so much room for remand. If you're not releasing people into the community, even with strict conditions, then you're remanding them. There are only so many beds in the remand centers. And there are practical consequences to incarcerating, well, I shouldn't use the word incarcerating, but to holding people pre-trial. So there's no funding attached to this. So are you concerned that there may be problems housing more people or getting more people to a timely trial?
Okay, so on the funding point, let me say to you that we have sort of broad funding under what we call the guns and gangs provisions, and some of that money is being used by the provinces on bail, and it's upwards of $300 million. Michael's nodding his head, so I think of 330. But on the second piece, what I'd also emphasize, Senator Simons, is that when you reverse an onus, in the normal course, the Crown must prove an individual is a risk and therefore should not be given bail. In this case, we're reversing the onus, but when reversing the onus, that doesn't mean an automatic detention, right? So it doesn't ipso facto mean by virtue of passing a piece of legislation that all people in the category that I've mentioned of serious violent repeat offenders with a weapon are going to be denied bail. It's just that they have to work harder to prove it, and it sends a signal to the courts around the country that this is what Parliament believes is necessary in order to keep Canadians safe. And I think what I would urge you to just consider is that in the parliamentary and political climate that we inhabit right now, to have unanimous consent on a bill and have 13 provinces all behind it and all of law enforcement behind it around the country is quite rare, because that is the sentiment around the country that this type of bill is needed for the security and safety of